Flood of accelerated divorces are hitting local attorneys and judges as a new law takes effect on January 1st.
Divorces finalized before that deadline will allow people expecting to pay spousal support to be able to deduct the money from their taxable income, and that could lead to huge tax savings for some people. Family law attorneys are scrambling to finalize before the end of the year, and that means busy courthouses in November and December. So here with more on the divorce tax law changes is attorney Ilona Antonyan. You are a family law specialist certified. Yeah. So tell us exactly, break it down, what is changing as of January 1st?
Yeah. So the IRS code 11051C is repealing the tax deductibility of spousal support effective January 1st, 2019. Before, people could write off the spousal support they're paying to their spouse, and the spouse who's receiving spousal support must declare it and pay taxes on it. Starting January 2019, it's going to be non-taxable to the recipient and non-deductible to the payor. So people are rushing right now to enter their divorce judgments prior to the end of the year, prior to December 31st, 2018. The new code section reads that any divorce or separation instrument that's defined as Section 71B2 of the IRS code executed after December 31st, 2018 is going to be subject to the new Tax Cuts and Job Act of 2017. And I looked today to see how, what is specifically divorce or separation instrument? What does that mean? Many people have temporary orders that are in effect. What happens with those temporary orders if you're not able to finalize your divorce before the end of the year? What happens if you signed an agreement, but it does not get stamped or signed by the judge before the end of the year? Does that matter? So in looking at the definition of IRS Code 71B2, divorce or separation agreement means one of three things. One, it's a decree of divorce, which means it will be a final judgment of divorce, resorting people back to their single status, or a separate maintenance agreement, or a written instrument incident to such a decree. So legalese, but just means get your divorce over with and final.
So even if you're legally separated, that doesn't count?
Correct. You have to have a decree of divorce. Decree of divorce means generally final dissolution. However, the word court order also is used.
It sounds pretty technical, but what about for couples who may not agree on everything in their divorce settlement? This would probably make them speed things up a little bit and say, hey, we need to get together on this because of tax purposes and get this ironed out before the end of the year.
They have options. One, there's a process called bifurcation of specific separate issues. So people who are still have a dispute over property division, custody, visitation, they can ask for a separate trial, a bifurcated trial on the issue of spousal support. They'll have to go ex parte, which means on an emergency basis before the judge, and the courts are packed right now. They barely have any court hearing dates to hear separate trials on permanent support. But they'll have to have a hearing on that, and then the court can issue a final divorce decree on that issue. Alternatively, parties can stipulate, pursuant to Civil Code of Procedure 664.6, without going to court, on the issue of permanent spousal support alone, and have it entered by the court prior to December 31st, 2018. Then that can be incorporated into the final judgment on all issues when all the remaining issues are resolved by way of agreement or through trial.
Cool. I'm glad you're a specialist.
Yeah, Uncle Sam's forcing everybody to speed it up if you're getting a divorce.
Start agreeing. Start agreeing with things, right?
Thanks for helping us.
Thanks so much for breaking that down.
You're welcome.
Yeah.
Well, the battle over the mission